To my right is the Honorable Daniel Talman, and to my left is the Honorable Craig Welling. We are Division 1 for today's oral arguments. We've got two oral arguments set for 9 o'clock. The first is People versus Wambolt, and I see that counsel for that case are at council table. The second is Michael B. Enterprises versus KB Homes. Our counsel for that second case here.
Yes, Your Honor. Yes, Your Honor.
All right, I'm going to direct some comments at all four counsel, both counsel for Wambolt and KB Homes. Have all four of you read our instructions for oral argument? Do any of the four of you have any questions about those instructions? All right. A couple of housekeeping details. Obviously, each argument that we'll be hearing today is 15 minutes aside. Second, if you have a phone or other electronic device like a pager, please turn it off, not just merely to silent, but off. And the reason for that is that we have a video recording and live streaming system here, and for some odd reason, when calls come into phones, there's a little bit of electromagnetic interference with our system. I mentioned that it's live streaming. Please don't say anything that's confidential because we can't get it back. If you say something that's confidential, it ends up going out to the world at large, and there's no way to retrieve it. The last thing is we very much appreciate folks being here today, and we're ready to proceed on People versus Wambolt.
Good morning. May it please the court, my name is Rachel Mercer, attorney registration number 47633, and I appear today on behalf of Mr. Jason Wambolt, the defendant appellant. And I'm just noticing that my time hasn't started. I plan to address issue 1 from the briefs. I believe all 3 issues are important, but because time is limited, I will only address issue 1, but I'm happy to answer questions related to issues 2 and 3. The facts of this case relevant to issue 1 are simple. Under count 1 of the complaint, Mr. Wambolt was charged with aggravated DARP, aggravated driving after revocation prohibited. He went to trial on this count and was found guilty of the lesser offense of DARP, driving after revocation prohibited. He was then retried under the same count of the complaint and convicted for the same offense a second time in front of a second jury. The only difference was that the second jury also found him guilty of the aggravator, which increased his offense from a Class 1 misdemeanor to a Class 6 felony. The question is whether trying and convicting Mr. Wambolt twice for the same offense violated the double jeopardy clause, and this court should find that it did. Now, there's a debate in this case about whether the additional element required to prove aggravated DARP is a sentence enhancer or whether that's a separate, greater offense. The answer to this question actually does not change the outcome of this case, because either way, Mr. Wambolt was retried for the same offense for which he had already been convicted. Either he was retried for the exact same offense plus a sentence enhancer, or he was retried for a greater offense, which was the same offense for double jeopardy purposes.
Ms. Mercer, let me back you up a little bit and ask you about the charge of ADARP. There wasn't a separate jury instruction on ADARP at either the first trial or the second trial. Can you explain why that was the case?
Yeah, they were following basically the Colgi, which suggests that you should have an instruction on the basic elements of DARP and then give the jury a verdict form on the basic elements of DARP and then give them an interrogatory, which includes the aggravator, which would indicate this is a sentence enhancer in this case and not a separate offense because it's just an additional element that raises the level of the offense. And everyone agreed on those instructions. And defense counsel pointed out, at the end of the first trial that effectively means that they were instructed on DARP as a lesser included offense of aggravated DARP, and that because it was possible for the jury to return a verdict on just that offense. And that is what the prosecutor agreed and consented to the court doing at the end of the first trial. And the state argues that it was permitted to retry Mr. Wambolt after the first trial because that first trial ended in a mistrial on the charge of aggravated DARP. But the first trial did not end in a mistrial. It ended in a conviction for DARP, which is a complete verdict on that offense, which is the same offense for double jeopardy purposes.
Pardon me for interrupting, Ms. Mercer. I'd like to pose a hypothetical, if I may, please. Would it, obviously, if we had someone charged with first-degree murder and second-degree murder, and the jury came back, and the instructions were the same here, they had the elements of second-degree murder and then an interrogatory with the additional elements for first-degree murder. In that situation, we would have the same result that you're asking for, right? We would have, if the jury came back and convicted of second, did not reach a verdict on the interrogatory, we would say that defendant was convicted of second-degree murder, could not be retried for first-degree murder. Isn't that what we would say?
Yes.
Okay.
Yeah, and so I think that's the same situation here, where if the state went ahead and accepted that verdict on second-degree murder, they couldn't then say, now I'd like to try again and build on that verdict and try to get that conviction for first-degree murder. And I think that's an important point, because this case involves a Class 6 felony. It involves aggravated DARP, which is generally maybe thought of as a lower-level offense, but the rule announced here would apply in many different cases. It would allow the state to basically ratchet up the punishment for an offense, accept a verdict on a lower-level offense, and then ratchet up that punishment in a second trial by representing the same offense to a second jury. So, for example, if you had robbery, they could accept a conviction for a simple robbery and then go to a second jury, and that's a Class 4 felony, and then go to a second jury and say, now I'd like you to find that he actually used a deadly weapon in the commission of this offense and had this certain intent to use that deadly weapon, and so that this is actually a Class 3 felony, and suddenly it becomes a Class 3 felony. So this would apply pretty broadly in a lot of different cases and situations. And one of the main points I want to make here is that the prosecutor definitely had the authority to ask for a mistrial in this case and had that option, because Section 18.1.408 gave the prosecutor that right. And that's the statute that says that without the consent of the prosecution, the jury cannot be instructed to return a verdict on a lesser offense if a greater offense has been submitted to them and any juror remains convinced that the defendant is guilty of that offense. And the prosecutor obviously knew about that statute in this case because, in fact, he actually read it into the record on the last day of trial when the parties were debating what the court should do about the hung jury. Now, he read it into the record when the parties were discussing whether the court could accept a verdict on driving while ability impaired as a lesser of DUI, but the same law applied to aggravated DARP and DARP. And the prosecutor chose not to exercise his rights under this statute and instead gave his consent when the court said it was just going to accept the jury's verdict on DARP. And by doing this, the prosecutor effectively gave up his right to retry Mr. Wambolt on the greater offense. And so if the prosecutor wanted to retry him, he just needed to ask for a mistrial, and then they could start with a clean slate in front of a new jury. And that's what the double jeopardy clause required. Now, the other case that I wanted to address, because there's some interesting language in one of the U.S. Supreme Court cases, Ohio v. Johnson. In that case, the court suggests that, or did say that a finding of guilt on one count of a multi-count indictment does not immediately raise a double jeopardy bar to continued prosecution on other counts that are greater or lesser included offenses. But the context in which the court made this statement is important because the facts of Ohio v. Johnson were quite different from the facts in this case. In Johnson, the defendant was charged with greater and lesser included offenses in one information, and over the prosecutor's objection, he entered a guilty plea to the lesser offenses and then argued that double jeopardy barred the state from prosecuting him for the greater offenses. And the U.S. Supreme Court found that that was improper and that he could be retried on the greater offenses in that case because he was not permitted to use the double jeopardy clause as a sword to prevent the state from completing its prosecution on the remaining charges. Johnson did not deal with a situation like the one we have here, where the prosecutor had a full and fair opportunity to prosecute Mr. Wambolt for the greater offense, and at the end of the trial chose to accept a verdict on the lesser offense.
Ms. Mercer, what about the Aguilar and Beller cases that the prosecution relies on?
Yes, I would argue that Aguilar was wrongly decided. That case did not deal with many of the issues raised in the briefs here, such as the questions of issue preclusion, the idea that the double jeopardy clause is designed to protect the finality of a jury verdict once it is accepted. and the prosecutorial overreaching involved in holding multiple trials on the same offense. And I would note that in Aguilar, the defendant was proceeding pro se, and so he may not have fully litigated the issues. And also in that case, that was actually a different posture. It was a 35C appeal of a Strickland claim. He was claiming that his counsel was ineffective for failing to raise the double jeopardy issue below. So it was a different posture combined with a pro se defendant that I'm not sure fully fleshed out the issues that have been presented to the court today. And Beller, the facts were quite different, because in that case, the defendant was charged with felony murder with the predicates of aggravated robbery and simple robbery, and then he was separately charged with aggravated robbery, and the jury acquitted on aggravated robbery and hung on the felony murder. And in the second trial, they went back and retried him for felony murder based with only with the predicate of simple robbery, which the court found didn't create a risk of inconsistent verdicts, because convicting him of felony murder based only on simple robbery was not necessarily inconsistent with the acquittal on aggravated robbery. And so Beller just presented a really different question than this case presents. This case is much more clear-cut. In this case, Mr. Wambolt did not try to use the double jeopardy clause as a sword against the state. He submitted to the first trial, allowed the state to fully present its case, and it's the prosecution who made the decision to end the prosecution on count 1 by accepting the verdict on DARP. And so if the court has no further questions, I'd like to reserve my remaining time for rebuttal.
Of course, you have about 5 minutes and 45 seconds.
Thank you.
Good morning, Your Honors. May it please the court, my name is Joseph Michaels, attorney registration number 40403. I'm here today on behalf of the people of the state of Colorado. I too will focus my arguments on the first issue, although I would like to take a brief moment to talk about a part of the second issue, and of course I am open to any questions on any of the issues that this court wishes me to entertain. I'd like to focus with the first issue on this issue of the aggravated DARP aggravator being a sentence enhancer and not an element. And I think that's probably the cleanest way to proceed in this case for several reasons. One, Your Honor, as Judge Taubman pointed out, the court below proceeded under that premise. It instructed the jury as though it was an aggravator, and it had the interrogatory in the verdict forms as though it was a sentence aggravator and not an element. And it had the prosecutor itself argue that this is a sentence enhancer and not an element. And two, it's consistent with a division of this court's opinion from back in 2013 called People versus Zubiotti, which explicitly said that it is just is a sentence enhancer and not an element.
Pardon me, Mr. Michaels, is Zubiotti still good law?
That is a good question. I don't mean to be flip with that, because quite honestly, there's been, as I pointed out in the second issue, there's been a significant amount of change in the law since this opening brief was written and since Zubiotti came out. My suspicion is that, yes, that part of Zubiotti still is good law in terms of it being a sentence enhancer versus an element. That was never addressed in the Supreme Court's decision in Zubiotti. It was certainly not in any way, shape, or form altered by the Supreme Court's subsequent articulation in Rock, the citations for which, of course, are in my answer brief. And to be completely frank, the Supreme Court in Rock didn't even disapprove of the result in Zubiotti to jump ahead to the second issue.
Well, hold on a second. Would you stop the clock for a moment, please? We'll let the gentleman take care of his phone, and I don't want you to be interrupted again.
Sure. Thank you. I appreciate that.
All right, let's start it up again, please.
So to answer your question as directly as possible, that part of Zubiotti remains good law. That aspect is still a sentence-enhancing aspect. The Supreme Court didn't change that in any way, shape, or form in its Zubiotti or in its subsequent opinions.
How did it get pled in the information? It didn't get. You typically see a sentence enhancer pleaded as the predicate offense and then a separate count, but designated as a sentence enhancer. How is it pleaded in the information here? It was pleaded as a charge, right?
It was pleaded in totality as a charge of aggravated DARP, and I think that's part of the discontent about this particular crime is that aggravated DARP is a thing unto itself because of the way it's structured in 42206. It has sort of alternate, section 1A talks about here's the crime of DARP, and then there's an alternate section 1B that talks about here's what aggravated DARP is. It's DARP plus any number of a series of subsequent offenses. But those offenses are almost always separately pled, which is what it was here. And that's where we get into our double jeopardy question here. We had that DUI, or ultimately what was a DWAI conviction in the second trial, but it was a DUI charge that was separately pled. And that was the charge that the jury couldn't have come to a decision on. And because they couldn't come to a decision on that, there was no opportunity for them to apply that determination about whether there was a guilt or innocence on the separate DUI charge to the aggravator of aggravated DARP. And that's why I think the two cases that this panel mentioned to opposing counsel, Aguilar and Beller, are very instructive in this respect, because both of those dealt with somewhat analogous situations, quite frankly. Both of those cases addressed felony murder. And felony murder, as this court knows, has a number of lesser included offenses. The ones relevant in those cases were aggravated robbery and burglary. And what the court found both the courts in those cases found persuasive was not this idea that they were acquitted of those counts, but rather that those counts were separately charged and separately pled. So to put that framework of Aguilar and Beller over here, what we're looking at is not that the DUI was sort of the enhancer for AgDARP. All these acronyms are making me run circles in my head, I apologize. But we're looking at this idea that in Aguilar, now I'm trying to figure out which one was it. Aguilar was the aggravated robbery one, and aggravated robbery was one of several different ways to charge felony murder. I think it's Aguilar.
I think it's Beller.
Beller. So then burglary must be for Aguilar, is that right?
I think so.
Yes, burglary is for Beller, I'm sorry. So with Aguilar, the aggravated robbery was separately charged, and because the separate charge, because he wasn't found guilty of aggravated robbery under the felony murder rubric, they were free to still retry felony murder. The same thing was true with Beller in burglary. It was one of several different ways in order that he could have been convicted, and because there were alternate methods of convicting, the felony murder was not precluded. Here, what would have happened and what would have sort of made a difference in terms of a double jeopardy analysis, assuming that we're talking about this implied acquittal and consent, is if the jury had actually returned in that first trial a verdict on DUI. But the jury didn't return any verdict on that. If it had returned a verdict on DUI and said, we find the defendant guilty, and then left the AgDARP charge or interrogatory unfilled out, then we would have this idea of, oh, there's an implied acquittal there, because that would be more like the felony murder situation where they had the opportunity, they'd found the underlying offense and didn't do anything with it. But we don't have that here. We don't have any verdict whatsoever rendered on that first aggravated DARP or DUI underpinning. And our Supreme Court and the U.S. Supreme Court have been absolutely clear that the failure to reach any jury verdict is not something that terminates jeopardy at all.
Mr. Michaels, let me go back to your statement a few minutes ago and your reliance on Zubiate, where you said that the division of our court there said that ADARP was a sentence enhancer rather than a separate offense. I wrote an opinion a long time ago in a case called People v. Wilson that said just the opposite. So why wouldn't that be applicable? Feel free to disagree and tell me that you think that was wrongly decided, but for what reason would you rely on Zubiate rather than Wilson?
At this point, I would rely on it much more. Your Wilson case, my recollection is that it was back from 2004. And Zubiotti is much more recent. The Supreme Court didn't alter that given the opportunity to do so.
But our court, with all due respect, divisions of our court can disagree with one another, and the mere fact that a decision is more recent doesn't mean that it's more correct.
No, and I agree with you, although I would point out that you were on that division with Zubiotti, and you concurred in that result.
Yes, I realize that, so I had to be correct in at least one of the opinions.
I think you automatically get to stand on that pedestal one way or another, sir. But I would note that the Supreme Court had the opportunity to correct that or alter that based on the cert petition, and they didn't do so. I would also note that in Zubiotti, and Zubiotti was a case that I was the attorney of record on in the Court of Appeals and in the Supreme Court, and the people presented that argument about whether or not it was an element versus a sentence enhancer, and the court flatly rejected me, so I was quite wrong in that case. And now I'm here making sort of a contrary argument. But I think to the extent that we look at those alternate methods of raising from the Class 1 misdemeanor to the Class 6 felony offense under AgDARP, it requires a separate finding based on a separate verdict form of DUI, of DWAI, of other things like reckless driving or vehicular eluding that are, of course, not at issue here. And I think more importantly is that our Supreme Court and divisions of this court have repeatedly undertaken this idea that sentence enhancers change only the underlying felony level. They don't change the elements necessary to prove it. In respect to AgDARP here, those elements, the DUI, the DWAI, the vehicular eluding, the reckless driving, they've all been proven by a separate count, except in this case where they had not, and where the jury explicitly said, we are divided about whether or not he is guilty of this other count.
Mr. Michaels, if ADARP is a sentence enhancer, isn't it true that Mr. Wambolt was convicted of DARP in both the first trial and the second trial?
Yes, that is true, but he specifically consented to having the jury readdress all the issues of DARP in the second trial. And the court instructed them consistent with that. I would also note, and my recollection is that the second trial was a two-tiered process where first they addressed just DUI, DWAI, and then after they received the verdict on that, they then went on to whether or not the interrogatory for ADARP had been proven. So it was a separate analysis, and the elements were provided, but there was no separate second jury verdict form for DARP in the second trial. It was merely finding the verdict form, or finding the enhancer for the special interrogatory.
Pardon me for interrupting, Mr. Michaels. I'd like to ask you to address the hypothetical that I asked Ms. Mercer. Let me remind you of it.
Please.
The case is a first-degree murder case, and in this case, for some reason, the court instructs the jury on second-degree murder and then provides the jury with an interrogatory with the additional elements for, let's say, intentional and deliberate murder. The jury does not, the jury convicts of second, but the jury does not do anything with the interrogatory.
Mm-hmm.
In that situation, do you think that the prosecution could retry the defendant for first-degree murder?
No, I do not. And the reason why is because that special interrogatory is a separate greater offense. And our Supreme Court in Ortiz was very clear that a conviction on that lesser included without any specific reference to a greater included means that that greater included, in this case, what would be the first-degree murder, is essentially an implied acquittal. And that's what 18-1-301-1A says. And Ortiz specifically references that. It basically says 18-1-301-1A has codified the implied acquittal rule that subsequently Aguilar identified as being different from the hung jury rule. So in this case, in your hypothetical, Your Honor, the jury has rendered a verdict. It has found second-degree murder. And on top of that, it has specifically rejected the additional elements of that would have amounted to first-degree murder. But that's not what we have here. The case that we have here is the jury never found the extra element, the extra enhancer, based on the DUI charge. And it was explicit about it. We're not left with a guessing game. The jury said, we can't come to a decision on this. Some of us think yes, some of us think no. And because of that lack of acquittal, there was no way to reach, or lack of acquittal, a lack of conviction, there was no way to reach the special interrogatory question.
What do you do with the 18-1408 argument that had the prosecution wanted to retry for ADARP, then they should have just mistried the whole case and not accepted the DARP verdict?
I have two responses to that, and one is what defense counsel candidly acknowledges, is that the prosecutor didn't consent to that for ADARP. They consented to it for DUI, DWAI, and that was the context of that conversation. The prosecutor thought that the jury couldn't determine whether Mr. Wambolt was guilty of DUI or DWAI, and so it said, well, either one satisfies the interrogatory for ADARP. So under Smith and Rediger, our recent Supreme Court cases that have articulated this idea of acquiescence, invited error, and waiver, that would be enough to get past the prosecutor's quote-unquote concession to allow that lesser-included verdict to go forward. But second of all, the 4088 talks about instructing the juror on, not accepting a guilty verdict from. At that point in time, the jury had already decided what the guilty verdict was regarding DARP. That's just outside the scope of 408A, or 4088, excuse me. I would just note that Lewis and Hogan and Golston, all cases from this, Hogan and Golston from this division, Lewis from the Supreme Court, and again, even the Supreme Court's decision in People versus Simon, have really reemphasized that sentence enhancers, such as this, are not subject to double jeopardy. They're not elements, they're not subject to double jeopardy preclusions, and it's not a situation where we're going to have subsequent trials, because basically the failure to find the existence of a modifier, such as DUI as a sentence enhancer in this case, would mean that there was specific acquittal if the element is otherwise proven by a verdict form. So if they had found the DUI and then just not, the hypothetical that I gave earlier, if they had found the DUI and then just failed to fill out the interrogatory, then we would have the implied acquittal. But implied acquittals, I see that I'm out of time. Do you mind if I finish my sentence? Thank you. The implied acquittal only applies when there are elements of the crime itself.
Thank you, Mr. Michaels.
Thank you.
Ms. Mercer, you've got 5 minutes and 45 seconds.
I just wanted to start by making the point that Mr. Wambolt does not concede that the prosecutor did not consent to the verdict on DARP. The prosecutor clearly consented to the verdict on DARP, and I would refer the court specifically to the transcript from July 24th, 2014, pages 76 through 80. The court told the prosecutor before the jury came back into the room that the court would be willing to accept a verdict on DARP, asked the parties if they were okay with that, and the parties said they had nothing to say. The prosecutor said, the court said, any comments, Mr. Bechtel, regarding that? And the prosecutor said, no, sir, thank you. The foreperson then told the court what verdicts they had agreed on, and the court then paused the proceedings and allowed the lawyers to approach and gave the DA yet another opportunity to object to the jury returning a verdict on DARP. So I would say he clearly consented to the verdict in this case. Additionally, Judge Welling, you asked a question about how aggravated DARP was charged in this case. There was only one count for aggravated DARP, but if you look at the language of count one, there's one sentence that talks about the basic elements of DARP, and then there's a second sentence that says, further, as part of the same criminal episode, the defendant committed the offense of DUI as part of the same. So that was basically the sentence enhancer. So I would argue that under that count, the count basically framed it as being charged as an additional sentence enhancer. And so that brings me to my next point, which is that the AG seems to agree with Mr. Wambolt, even though there's been some debate on this court, that this is in fact a sentence enhancer in this case. And I think that makes this case even more clear-cut, because a sentence enhancer is an element of the aggravated offense. And the state says that it's not an essential element, meaning you can be convicted of the basic offense, but that doesn't mean it's not an element. It still has to be proven in order to support a conviction for the aggravated offense. It has to be proven beyond a reasonable doubt. And Mr. Wambolt had a right to have his trial completed by one jury. You can't have piecemeal verdicts. You can't have one jury render a verdict on some elements and then go to a second jury and try to ratchet up the punishment by adding an additional element.
Well, Ms. Mercer, what about the fact that in the second trial, the jury was instructed on DARP as well as the aggravating factors?
And I would say that was problematic because what you're doing is you're resubmitting the elements that have already been ruled on by one jury to a second jury, and you're running the risk of inconsistent verdicts.
What is your response to Mr. Michael's contention that that was done at the request of the defendant?
I would say that, first of all, Mr. Wambolt completely objected to the second trial, and second of all, that error in resubmitting the DARP elements to the second jury was inevitable once the court chose to hold the second trial, because there was no way for the jury to answer the interrogatory on the aggravator without reconsidering the elements of DARP. The jury was asked to decide whether Mr. Wambolt committed DARP and DUI as part of the same criminal episode. To answer that question, they had to first find out when and where he committed DARP so they could decide whether it was part of the same criminal episode as DUI. There was just no way for them not to reconsider the elements of DARP. And I'll note that the trial court, if you look at the transcript from, I think it's July 28th and October 10th, really tried hard not to give the DARP elements to the second jury and said, I'm not going to give them a verdict on DARP. I'm not going to resubmit those elements because we already have a verdict on those elements. But it still had to. There was just no way for the second jury to rule on the interrogatory.
May I test that, Ms. Mercer?
Sure.
Why couldn't the court simply say, jury, you have a couple of things to figure out here, but one of those things is not whether he committed DARP. I'm instructing you that he did, and that the parties agree that he committed DARP. What you have to find out is whether or not he did these additional things in the context of that. And in that way, the jury does not twice determine that he committed DARP.
I'd say that would be unfair to Mr. Wambolt because as part of double jeopardy, he has a valued right to have his trial completed by a single tribunal. And there, what you are effectively doing is patching together the verdicts from two separate juries in order to support one conviction. The state gets one opportunity to try Mr. Wambolt, and if he wanted to go again on the second offense, they needed to ask for a mistrial and start fresh with the second jury. It's simply unfair to Mr. Wambolt for the state to be able to use the first trial to establish a floor and then try to build on it in front of a second jury. They need to present all the elements of the offense and give the jury the opportunity to weigh all of those elements and render a complete verdict on the offense. And so I would say that you can't separate out the sentence enhancer in this case, and in most cases, it's impossible. And so this error was clearly non-invited. Finally, I just wanted to say that the DUI charge was a separate charge in the complaint. There did not need to be a separate verdict form for DUI in order to charge someone with aggravated DARP. They could just be charged with aggravated DARP. In this case, the jury rendered a verdict on DUI, or did not render a verdict on DUI, but did render a verdict on driving after revocation prohibited, which is the same offense as aggravated DARP for purposes of double jeopardy. And at that moment, the prosecution on count one was at an end. And for those reasons, Mr. Wambolt would ask this court to reverse his conviction for aggravated DARP and remand for entry of judgment on the first jury's DARP verdict. If the court does have any questions.
Thank you, Ms. Mercer. Thank you, counsel. We very much appreciate your arguments in this case today. The case will stand submitted and an opinion will issue in due course. If counsel for the Wambolt Please go ahead, counsel.
May it please the court. My name is Glenn Porzak, attorney registration number 2793. Your Honors, the entire basis of this action is to protect and enforce a natural drainage easement, and that's an interest in real property. Appellants submit that KB Home actions have obstructed the appellant's natural drainage easement in violation of long-established law, which gives the landowner the natural easement across a downstream or adjacent property to drain the surface water. We submit that the applicable statute of limitations in this kind of action is CRS 3841-101, which involves the enforcement of real property aspects or easements. In fact, that statute of limitations is for 18 years and specifically states to enforce or establish any right or interest of or to real property.
Mr.
Yes, Your Honor.
Porzak, even if you're correct that that statute of limitations applies, wouldn't it be overridden by a statute of repose?
We do not believe so, because the statute that I've just cited that applies to real property is very specifically tailored to an interest in real property, whereas the statute of repose is more general in nature. But that your question really gets at the heart of this case in many respects, because the basis of KB Home's summary judgment motion and then the trial court's order was clear that the statute of repose is applicable to construction defects claims arising under what's known as SIDARA, which is the Colorado Construction Defect Action Reform Act. And the integral connection between SIDARA and the statute of repose is confirmed by the case of Smith versus Executive Custom Homes that was cited in our reply brief. And that was the basis under which the court dismissed appellant's lawsuit by its order granting their motion for summary judgment. We submit, however, that this is a case of first impression because SIDARA and the statute of repose have never been held to apply with respect to a taking of an interest in real property, where number one, there was no privity of contract with the owner of the real property that was being taken, and the cause of action had vested, and this is important, had vested prior to the expiration of the statute of repose.
Pardon me for
Yes, sir.
interrupting, Mr. Porzak. I'd like to make sure that I understand a couple of aspects of the record. First, am I correct that your client did not own this property at the time all this work was done?
That's correct, Your Honor.
You came in later. Your
That-
client came in later.
Yes, that's correct.
My second question is, am I correct in my reading of your complaint that you allege that KB Home defectively changed the ground in Berkshire in a way that interfered with your easement?
That was one of a number of claims that were in the complaint. However, the genesis of it was that it was not that their actions were defective or their construction was defective. In fact, it was effective in raising the whole gradient of their property some 5 feet, which blocked the natural drainage easement. And that was the heart of the case. With respect to your first question regarding the ownership, the appellants came into ownership within the period, the 18-year period statute of limitations that we feel is the statute of limitations that should be applied in this case.
And I have one more
You bet.
question. KB Homes did not own any of the properties in Berkshire, is that correct? I couldn't find any indication in the record that they did own any of the homes, any of the property at all.
Well, they were the ones that came in and developed the entire subdivision. So, and it was their contractors who performed all
I
the
understand
the
that,
work.
but my question is ownership of the property. Is there any indication that KB owned the property?
I guess I don't have an answer for you on that, other than I don't know how they would be able to affect all the construction and do the development if they did not have an ownership interest in the property.
All right, but the record, you're telling me that the record's silent on that?
Well, I guess what I'm telling you is that I don't know. The record is really all of the briefs effectively and the pleadings in this case. There was no evidence that was ever, taken in this case. Let me address, though, to the extent that the court, however, finds that SIDARA and the statute of repose do apply, we submit that that would amount to unconstitutional taking of property without due process, given the lack of privity of contract between the parties and the lack of notice that was given. I think the heart of this case is that this is not a matter where the design and construction practices of KB Home and the contractors were defective or otherwise faulty with regard to the homes in their residential development that they created. That's clearly the kind of case where SIDARA and the statute of repose are applicable. This is a matter where KB Home's actions unlawfully interfered with appellant's natural drainage easement. And again, we submit that's governed by the principles of easement law and the 18-year statute of limitations. In this regard, it's real important to note that KB Home states for the first time in its answer brief that it's not relevant whether the claims at issue are subject to SIDARA. But yet that's contrary to the entire basis of their motion for summary judgment and the trial court decision. I'd only ask you to turn to the second page of the trial court's order, and it said, defendant asserts that the Colorado Construction Defect Action Reform Act, SIDARA, governs plaintiff's claims. Therefore, defendant argues plaintiff's claims is barred by that act's 6-year statute of repose. And then when you get to the body on page 4, their analysis, which is just 2.5 pages, it's entitled Colorado Construction Defect Action Reform Act. And the entire basis is that it is subject. But and that connection, again, is important from the Smith v. Executive Custom Homes case cited. Simply put, the current form of statute of repose is limited to construction defect claims. And yet this case does not involve a defect in improvement to real property or personal property. They never did any, according to their responses, never did any construction work on the appellant's property. And there's no need to determine, that aspect. The pertinent inquiry is whether or not they unreasonably interfered with the appellant's natural drainage easement. Let me hit 2 points. One is that the 18-year statute of limitation is longer precisely to give landowners more time to defend an interest in real property from being extinguished. And that's particularly clear when it comes to a drainage easement, where it might not manifest itself for many years. And the legislature gave no indication that SIDARA and the statute of repose replaced existing 18-year statute of limitation. I want to address what I believe is the primary case that KB Homes addresses and uses to support their arguments, and that's the Yarborough versus Hilton Homes Corporation case. In that case, the court narrowly found that the statute of repose did not violate due process, but it's important to note that there's a number of very critical distinctions. First, the main reason Yarborough found that the application of the statute of repose did not violate due process because the time for filing the suit had lapsed pursuant to the statute of repose prior to the cause of action arising or became vested. In the case at hand, the cause of action arose and vested as soon as the natural drainage easement was blocked, which was well within the period of the statute of repose. And address the court's attention.
Why doesn't that argument cut against
you bet.
Why doesn't that argument cut against you?
It doesn't, because that's really the law review article that we cited, and then other jurisdictions where they found differently, where it says the situation posing a more serious challenge to statutes of repose involves the operation of statutes in extinguishing an already accrued right. And that's the heart of the distinction here, that the right had already accrued. And then that's really what other jurisdictions, the Wisconsin court case, the Hunter versus School District case we cited, where they determined that states' statute of repose violates the due process clause or applied to eliminate a vested or accrued cause of action.
Mr. Porzak, what
yes.
evidence is there in the record as to when the cause of action with regard to your client accrued?
It would have accrued in, I believe the record was 2006 or 2007. That's when the construction existed, where the grade was increased by some 5 feet, which it didn't manifest itself later until I think it was 2013, 2014.
So I guess that's my question is,
Yeah.
obviously the 2013 floods that we experienced made this manifestly obvious that this was potentially a problem, but was it discoverable before that? And does that matter?
Well, there was never any issue, and we know from Loch Buoy town officials who, you know, that the new subdivision is within, they never saw that as an issue until the, you know, obviously the flooding events, and that's when the ponding started to occur and has continued to occur. If you have no other questions, I'd like to reserve my last 3.5 minutes, I guess.
Of course.
Thank you, Your Honor.
Yeah,
May-
are you looking for a switch to make it go up and down?
Yes.
It's right there on the right-hand side. Up top.
Oh, I see. I don't see it, so I'll just.
Oh, okay, the bailiff will come and help you out.
Oh, I see. Thanks.
Is that better?
Better, thank you.
You're welcome.
May it please the court, my name is Spencer Sears, bar registration number 34234. I represent KB Home, Colorado, the appellee in this matter. Your Honors, close to 50 years ago, the Colorado State Legislature made an unambiguous and clear determination that there was a legitimate public purpose in limiting the time frame in which to bring actions against construction professionals for damages arising out of the design and construction of improvements to real property. In doing so, the legislature enacted 1380-127, which provided for a 10-year statute of repose for such claims. That determination was reaffirmed in 1986 when the Colorado State Legislature enacted 1380-104, a statute almost identical to 1380-127, but which provided for a 6-year statute of repose. The legitimate public purpose for enacting the construction statute of repose has been discussed in other opinions of this court, and most notably in the Colorado Supreme Court decision in Yarborough. It bears repeating here. Because most construction projects have a useful life over many decades, there's a legitimate purpose in providing construction professionals with a reasonable expectation as to when their potential liability will be extinguished. Codes and standards change over time, memories fade, documents are lost, are all legitimate reasons to limit the time period for claims against construction professionals. Encouraging development and construction is another. By its plain language, the 6-year repose period in 1380-104 applies so long as the action is against a certain type of professional who is engaged in a certain type of activity. It is not dependent upon a particular claim, type of claim, or category of damages. Now, plaintiffs allege that the statute does not apply to their claims for trespass, nuisance, and intentional interference with a natural easement because their claims are based on a real property right. However, plaintiffs have not and cannot cite to a single case which would so limit the application of 1380-104. The great emphasis that plaintiffs place on case law discussing the natural drainage easement possessed by an upstream property owner simply are not applicable here. Because even assuming, for the sake of argument, that plaintiffs hold a natural drainage easement, this right does not provide them with an unwritten exception to the statute of repose in 1380-104. Again, the statute applies by its plain language to all actions against construction professionals performing or furnishing the building of an improvement to real property. It is not for this court to write in the limitations into the statute where none exist, or to second-guess the legislature's finding of a legitimate public purpose in enacting the statute. And this case is not just a case of a simple real property dispute in which the trial court just needs to make a determination as to whether the interference with plaintiff's easement is reasonable or not. And what plaintiff suggests is that if unreasonable, injunctive relief would be the remedy. All of the cases cited by plaintiffs for this proposition involve claims from a dominant estate holder against the neighboring servient estate holder. And to answer your question, Judge Bernard, KB Home did own the property at one point, but that was vested of all that ownership interest when the construction was complete and they transferred the ownership to the homeowners who purchased that property, the last of which was in July 31, 2007.
So, in other words, KB Home did not own any of the property after the 31st of July of 2007.
Correct, and that's what the record shows, Your Honor.
Thank you.
And so, again, this is not a simple real property dispute between two landowners. An injunctive relief is not the appropriate remedy against KB because KB does not currently own any of the property that plaintiffs claim are impeding their drainage easement. It would be impossible for KB to comply with any court order for removal of the homes, regrading, or other injunctive or restorative relief. And so that really kind of goes to the nature of what the claims here. And I think the plaintiffs realize this issue because they are not claiming non-monetary declaratory and injunctive relief like the claimants in the cases cited by plaintiffs in their briefing. In this case, plaintiffs are claiming monetary damages as to all claims asserted, including their claims for interference with the drainage easement and injunctive relief. And these claims for monetary damages are based upon KB's construction activities.
Mr. Sears, I'm confused by what you're saying about monetary claims and injunctive relief. I thought that injunctive relief was an alternative to a request for monetary damages.
I would agree with you, Judge Taubman. That's not how it was pled in plaintiff's complaint. They specifically requested injunctive relief, ordering KB to pay for a drainage solution to repair what they allege, and it is clear that they allege was defective grading and drainage of the Berkshire subdivision by KB Home. And so plaintiffs may or may not possess a natural drainage easement across downstream land. But if they're going to bring a claim for damages, money damages is what they've done here, regardless of the labels given to the claims, they're bringing those claims against a construction professional, such as KB, for building an improvement to real property, then those claims are subject to CRS 1380-104. And this assertion by plaintiffs that their claims do not arise out of alleged deficiencies or defects in KB's Home's work only surfaced when responding to KB's motion for summary judgment. It was clear that in their complaint, plaintiffs alleged that KB did not construct the homes in accordance with Town of Lochbuie requirements or the submitted plans. In an interrogatory response, plaintiffs alleged the same thing. In fact, we submitted a request for admission to plaintiffs, asking plaintiffs to admit, and I quote, that there are no defects in KB's design or construction of Berkshire which serve as the basis for your claims for relief. Plaintiffs denied this request. In explaining their denial, plaintiffs stated, the design and/or construction of the Berkshire Development and Drainage Plan are inadequate to handle the historic drainage levels and are therefore defective. And so plaintiffs want to kind of hide from these admissions now, but the fact is that these are binding judicial admissions set forth in their complaint and set forth in written discovery responses. This is inherently and unavoidably for plaintiffs a defective design and construction case. It's further reflected by the fact that plaintiffs are requesting for money to implement a repair solution. And the trial court noted in its order the inherent conflict in what plaintiffs are claiming now versus, or what they claimed in their complaint versus what they're claiming in their argument in opposition to summary judgment. If it wasn't allegedly defective to begin with, in fact, if KB's grading had accounted for the historic flows, then there would be no need for a repair solution and there would be no lawsuit. And the 2 Denver Highlands case is the case that we believe is directly on point, in that Judge Tompin, you served on the panel, and in that case, the court looked at CRS 1380-104, in upholding the trial court's determination that the statute of repose applied. The 2 Denver Highlands courts focused on the broad scope of the statute and noted that in order to apply the statute, the trial court's inquiry is limited to the type of individual involved and the type of activity involved. And so the question under the statute as to the type of individual involved is straightforward. Is a defendant an architect, contractor, builder, vendor, engineer, or inspector? That's undisputed here. KB is clearly a contractor, builder, and vendor, and plaintiffs do not dispute that. As to the second prong, what the 2 Denver Highlands courts said is that the trial court and courts of appeals should conduct an activity analysis. The conduct at issue must originate from an activity that the statute was designed to protect, and that's the process of building an improvement to real property. Colorado law is clear that grading activities are among the type of building activities covered by CRS 1380-104. I would point this court to the Highline Village Associates case at 996 P. 2nd 250, Colorado Court of Appeals case in 1999, cited in our briefs, as well as the Embry case at 684 P. 2nd 951. The fact that the plaintiff in 2 Denver Highlands labeled its claims in the nature of products liability played no role whatsoever in the court's analysis there. It's not the labels that the plaintiffs put on its claim that matter for the analysis, and the fact that plaintiffs here want to label their claims in the nature of a real property dispute doesn't matter for the analysis that this court should conduct. KB Homes is a builder. Plaintiffs' claims originate from the activity of building an improvement to real property. As such, this action is covered by CRS 1380-104.
And as I understand their argument and how they're trying to square the allegations of defect from the applicability of SIDARA, is not that they're saying that there was no defective construction. They're just saying that's not a necessary element of the claim that they're asserting. Just because there happens to be allegations of a defect here doesn't mean that it converts it into a SIDARA claim, because that's not necessary to their claim. Had this been perfectly built to spec and to plan, they would still be in a position to assert the same real property claim. At least that's my understanding of how they're trying to sort of square this circle.
I understand that, and I think that's a fair reading of what their argument is. But the distinction in that this is not a SIDARA claim, 1380-104 was enacted almost 15 years before SIDARA was enacted. And the analysis that this court must conduct to determine whether these claims are subject to 1380-104 is, again, that activity analysis. And when the activity analysis here shows clearly their claims arise out of a building activity, whether defective or not defective. But they cannot avoid the fact that these are related to a deficiency or a defect in construction, because, again, if the grading had been done appropriately, as they allege, it should have accounted for historic flows. The grading did not account for historic flows. Therefore, these are claims that arise out of that activity, failing to account for historic flows, and they arise out of the activity of building an improvement to real property, for which the Court of Appeals has already held grading is.
Can you give me another example of a statute of repose that is shorter than the statute of limitation?
I'm not aware, and I don't believe, the statute of limitations reference 13, I believe it's 13.
41-101?
Yes, thank you, Judge
Or,
Welling.
Actually, 38-41-101.
Okay.
Is that the one that they're referring to?
Yes, that is the statute for adverse possession. It's a codification of the common law for adverse possession. This is not a claim that KB is seeking title to or otherwise adversely possessing plaintiff's property. This is not that claim. That statute of limitations does not apply here, because this is not an adverse possession case. And the statute of repose at 14104 is mutually exclusive. It's not a more general statute than the adverse possession statute of limitations. They're mutually exclusive. They're for two different kinds of claims. This is not an adverse possession claim. This is a claim against a construction professional arising out of that construction professional's activities, building an improvement to real property. With respect to the Yarborough case, the Yarborough case is directly on point with respect to plaintiff's claims that 1380-104 is unconstitutional because the Colorado Supreme Court has already squarely ruled on the issue. 1380-104, the construction statute of repose, is constitutional. The Yarborough court held it was not unreasonable for the legislature to limit the time in which claimants can bring suit against construction professionals in light of those legitimate purposes I discussed on the outset.
What do you do with this distinction that they're drawing with Yarborough of a vested versus a claim that is yet to arise before the expiration of the statute of repose?
KB here is similarly situated to the defendants in Yarborough in that plaintiffs do not have a vested property right at the time that the statute of repose extinguished the claims against KB, because plaintiff did not own the property in July of 2013 when the statute of repose extinguished claims against KB Home. Thus, plaintiffs had no vested property right the time that KB Homes became immune from suit. That's very similar to the construction professional involved in the Yarborough case because the defect in the alleged design defect discovered in Yarborough was discovered after the statute of repose had extinguished liability for the construction professional, similar to what we have here. So there was no vested right that was from plaintiffs that was taken by the statute of repose because they had no right at the time that the liability was extinguished.
Mr. Sears, why wouldn't there, or couldn't there have been a vested right that in, excuse me, in the predecessor owner to plaintiffs that extended to plaintiffs when they acquired the property?
Well, there was no such transfer of that right, but that right was extinguished when the statute of repose time period was up. So that right was extinguished in as of July 31, 2013. The prior plaintiffs, and the alleged flooding here was noticeable and discoverable well before 2013. The prior property owner did not bring that claim. No claim was brought, and then the right was extinguished. I see that my time is up. Unless there's other questions from your honors, KB would ask that the court affirm the trial court's order granting summary judgment in KB Homes' favor. Thank you.
Thank you, counsel. Mr. Porzak, you have 3 minutes and 23 seconds.
Thank you, Your Honor. First of all, the right did vest when the drainage easement was blocked, and when the appellants purchased the property, they stepped into the shoes of that prior owner. Also, we would agree that it's not the label, if you will. The fact is that that this is an impairment of an interest in real property, and that's why 3841-101 controls, because that, and I quote, is to enforce any right to real property.
Then why isn't this a claim against the owners of the property? You essentially are asserting that you have an enforceable easement against the upstream property owners. You haven't sued the owners of the property over whose property you are asserting an easement, right?
That's correct.
Why not?
Because KB Home was the servient owner when the blockage of the natural drainage easement occurred. The current owners did not cause the impairment of appellant's natural drainage easement.
But they're the owners of the property over whom you're asserting an easement, and they're the current owners. To the extent that they then want to turn and seek recompense from others who may have caused it, that's up to them. But isn't your claim really against the owners as you're styling your claim?
Part of the problem there is that where the easement would have gone to is within the town of Lochbuie, and so we would have, if you joined them, they would have dismissed for because of their governmental powers. But I do want to address your other how you characterized the nature of the claim, and you were correct in terms of how you characterized the cause of action that, and your reading of the complaint, if you will.
Well, now what it sounds like you're saying is, gee, we've got some other people that maybe we could have named, but they're barred from the suit, so now we're going to go after the one party that's available, and their role in all of this was as a builder, and they fall into a different, by virtue of their role in this, have different protections that they're asserting here.
Well, I guess I disagree with the notion, Your Honor, that somehow they fall into a different notion because they're a builder, if you will. The state legislature never said that somehow the statute of repose in Sadara canceled out the 18-year statute of limitation, mainly just because someone's a builder. But if again, KB Homes was the entity that caused the impairment of the natural drainage easement.
What did they do to cause it?
They clearly through the entire development and raising the grade. But the problem was they never did anything on the appellant's property. Everything was on their own property, if you will. I see that I'm out of time, so I'll just leave it there.
Thank you, Mr.
Thank you very
Forsythe.
much, Your Honors.
Thank you. Counsel, thank you for your arguments today. We appreciate them. The case will stand submitted, and an opinion will issue in due course.
May it please the court. My name is David Dworkin. My registration number is 14982. I represent the petitioner, City of Boulder Fire Department. I'd like to reserve 3 minutes.
Counsel, it's up to you to watch your time.
Very well. We are here on employer's appeal of a workers' compensation firefighter cancer claim. The core issue concerns the correct construction and application of the proof regarding the rebuttable presumption in the firefighter statute CRS 841-209, as construed by a trio of Colorado Supreme Court cases decided in 2016. Those cases are City of Littleton, Town of Castle Rock, and City of Englewood. The trio of cases held that an employer may overcome the statutory presumption that firefighter duties cause cancer by showing by a preponderance of the medical evidence either that the firefighter's known or typical occupational exposures are not capable of causing the type of cancer at issue, or that the firefighter's employment did not cause the firefighter's particular cancer, where there are medical risk factor evidence that renders it more probable that the cause of the claimant's condition or impairment was not job-related. In this particular case, very briefly, the firefighter was diagnosed with tongue cancer. Test results were positive for a cancer-causing human papillomavirus, or HPV, subtype 1618, which is a sexually transmitted strain associated with the firefighter's specific type of tongue cancer. The ALJ concluded in part, it is well settled that the cancer is related to the HPV virus. The ALJ added, what is less clear is the relationship between the firefighter's exposure to carcinogens at work and the development of the cancer in question. The ALJ then credited the claimant's experts that the tongue cancer was multifactorial and concluded that the employer failed to overcome the statutory presumption of relatedness and established that it is more likely than not that the firefighter's employment did not cause claimant's particular cancer, or that the firefighter's cancer was not caused by his exposure to carcinogens while employed as a firefighter. The City of Boulder seeks relief in overturning the ALJ's determination and finding as a matter of law that the HPV subtype 1618 was a greater risk factor that rendered it more probable that the firefighter's cancer arose from a source outside of the workplace. In its basic form, the city is asking the court to look at and interpret the statutory and the case law requirements of what does the judge have to do in order to make a determination, in this case, on compensability. The trio of cases talks about that there can be presented general evidence of causation as well as specific evidence of causation. In this case, the lines are a little blurred because of the HPV strain. In essence, the city presented evidence that there was no general causal link. And in doing so, pointed out that the firefighter's specific cancer does not exist without the HPV virus. The specific cancer does occur in a lot of people who are not firefighters, and therefore, under general causation principles, there is no general causal link. By the same token, the specific alternative causation risk factor analysis applies in this case. The HPV, again, is the specific cancer that gives rise to or specific element that gives rise to this cancer. And the question was whether or not there was a synergistic effect presented by the claimant or the firefighter's experts that caused or was necessary to cause the cancer. And the respondent, or the city, I use respondent and claimant, I apologize, that's how we talk about it in terms of the workers' compensation area, pointed out that this particular firefighter had left his employment 2 years before the cancer existed. And therefore, if we look at what is the most reasonable or most probable under the test of the three cases, cause of this particular firefighter's cancer, we come back to the HPV situation because there were no occupational exposures which are required under the occupational disease standard. There were no occupational exposures for the 2 years preceding the development of the cancer.
Pardon me for interrupting, Mr. Dworkin, if I may, please. Correct me if I'm wrong here, but your briefs in particular seem to argue that what the ALJ should have done was rank causes.
Yes, sir.
Is that your position?
That's the primary position, yes, sir.
Could you please point out in any of the trio of cases that you have referred to, specific language that says that it is the ALJ's obligation to do such ranking?
And I will point to primarily the town of Castle Rock. I think Littleton also addresses it somewhat, but it's primarily the town of Castle Rock. And in the town of Castle Rock, they point out the employer need only establish by a preponderance of the medical evidence that the firefighter's employment did not cause the firefighter's cancer because the firefighter's particular risk factors render it more probable that the firefighter's cancer arose from a source outside the workplace. The emphasis there being on probability relating to the risk factor analysis. The way I interpret these cases, and part of what I'm looking for in terms of guidance here is that because the courts talked about the general way to counteract or rebut the presumption and the specific way, and that the general way to rebut is open for the judge based on a preponderance of the evidence standard. Either I agree that there was no other cause, or this couldn't have been caused by this outside factor, or I disagree, preponderance of the evidence standard. But when we get to the specific risk factor section, I read those cases to say we have to then do a risk factor analysis, because it talks about the risk factor particular test rendering it more probable. And then the judge is supposed to look at and weigh which risk factor is the more probable risk factor, which was not done in this particular case.
Mr. Dworkin, how does your analysis jive with the cases that have held that a worker who has a pre-existing condition can nevertheless get workers' compensation benefits if that condition is exacerbated or worsened by some kind of job-related activity?
Those particular cases are the normal, that's the normal line of law in a workers' compensation case. And what we're talking about here, it's a little separated from that in the sense that we are not talking about an injury, we're talking about an occupational disease. And an occupational disease has a different standard, which is that the claimant needs to prove that the hazards of employment were a significant causative factor for the development of the cancer. And this differs a little bit from the occupational disease standard as well, because the court and the legislature have flipped it and made it a rebuttable presumption that these particular types of cancers are related. And also then I think have given us the ability to overturn it by a probability factor. What's also interesting about, I think, your question is that under the normal occupational disease standard, we look at cases like Anderson versus Brinkhoff, which the Supreme Court decided in 1993, and held that where there is no evidence that the occupational exposure to a hazard is a necessary precondition to the development of the disease, the claimant suffers from an occupational disease only to the extent that the occupational exposure contributed to the disability. So essentially, creating a percentage of impairment. How much do we attribute to this pre-existing condition, and how much do we attribute to the work-related aggravation or occupational exposure? So in essence, also a risk factor analysis, which was not applied in this case by the judge. It's also, when I look at the facts of this case and the way that the judge prepared his order, the judge did not make the determination, as far as I can read, that the work-related exposures aggravated a pre-existing condition. I read the judge's order to indicate, and even the testimony of the experts, that the respondents did not overcome the presumption of relatedness. And it was based on this multifactorial argument that the claimant was exposed to all these different kinds of things, maybe while fighting fires, couldn't specifically say he was, couldn't specifically say to what extent, but without that, there's this synergistic effect that probably worked with the HPV, was the argument made by the experts, because not everyone with HPV gets cancer. That's a weighing mechanism that doesn't make sense to me personally, because not everyone who's a firefighter with HPV gets cancer, and a lot of people who are not firefighters with HPV get that cancer. But no one gets that cancer without the HPV. And so it was really a burden of proof argument or conclusion by the judge, not saying, yes, I find that work-related exposures aggravated or accelerated the underlying condition. So hopefully that answered the question. Instead, it's our position that the judge relied on the multifactorial analysis that was specifically rejected by the Supreme Court in the city of Littleton. In that particular situation, they talked about you can't just throw out there that the firefighter may have been exposed to these multifactorial elements that may have contributed to his situation, that creates an irrebuttable presumption. And that's not the situation, which again goes back to why I think that the court is required to do a ranking. They can't just have a generalized category out there. I also read these to indicate that we're looking at risk factors versus causation. That's a question that comes up. Is risk factor the same as causation? And I would argue that in this particular case, there's a difference between a scientific causation, which is, hey, what does the science tell us is the cause of this particular situation, versus a legal causation, which is, as I read it, these risk factors can lead to determining causation because you look at what's most probable. And by looking at what's most probable, that becomes the cause of this particular condition. And at that point, unless there's a question, I'll reserve the rest of my time.
Members of the panel, council, my name is Neil O'Toole, and I represent firefighter Pacello. I have been up here before on these cases, and I am familiar with the operation of 841-209, and there's no dispute that the claimant met the threshold requirement. The dispute is how the ALJ measured the evidence. Now, the city of Littleton is brought up numerous times by council. I refer to that as City of Littleton versus Christ, because Christ was the individual who had brain cancer. And that's where this whole discussion of general versus specific was enumerated, expanded on, described by the Supreme Court. In that case, the ultimate holding was that the ALJ below had her decision supported by substantial evidence and should not have been, and that decision should not have been disturbed by either ICAO, which opinion, and the Court of Appeals. So that was what that decision said. Now, I cannot stand here, I'm not going to stand here and tell you that this case could only have gone the way it went. That was for the ALJ to determine. Hundreds of pages of description of medical records. But one thing that it is not required is to show, and I guess that's what is told by the trio of cases, and every one of them seems to agree on this, is respondents do not have to show a specific cause in order to overcome the presumption. But then again, neither does the claimant. The purpose of the statute is to shift the burden of proof to protect firefighters.
Pardon me for interrupting, Mr. Earl.
Sure, oh, please.
Understanding that that's the case, that the statute shifts the burden,
Right.
isn't this just a battle of the experts cases, and the ALJ listened to both sides and then made determinations based on keeping that burden, that shifting of the burden in mind, and made determinations based on the evidence that the ALJ heard?
That is ultimately our position. Candidly, I could have lost this case. I've lost them at the ALJ level. I haven't lost many, but I've lost them at the ALJ level. And when I lose them at the ALJ level, in light of City of Littleton versus Christ, I'm not at ICAO, because they've argued this back and forth, and honestly, no one knows the cause, and I'm putting that word cause, not risk, the cause of cancer. As Mukherjee says in his description of the emperor of all maladies, there's a question of correlations. It's not a question of causation. I don't know if I do know that not everyone contracts squamous cell cancer. I would disagree with Mr. Dworkin. He said nobody contracts this type of digestive cancer without HPV. Well, because I do a number of firefighter cases, that's really not accurate. I just opened a case with a guy who I said, well, you got HPV. I'm looking at this argument because that is presumed to be the cause. But nobody knows where this came from. Nobody knows where the HPV came from. We know it exists. And what has been determined is that it is not what this is all about. It's the exposure to carcinogens when combined synergistically with that exposure to, which is really a pre-existing condition. So our position is, yes, this is a question that was before the ALJ. Yes, the respondents could have prevailed. I should say the department could have prevailed. Dean Pacello prevailed. 35 years in the service of Boulder. 2 years after retiring, he develops this obscene disease. And the question is, what were the contributing factors? Nothing was argued about apportionment because that's not really what has happened in these cases. It's really an all or nothing deal. If you go to hearing on it, the question is, whose experts are to be believed? Are you to believe Dr. Bell, who said he knows little or nothing about firefighting? Who said he doesn't know what even causes HPV? Now, again, it exists. It's in this case. I can't get around it. I never argued that HPV was not a factor. Or I should say, Dean Pacello never argued that through me. The fact is, we believe that we supported, that this decision was supported adequately by the evidence, which included not only an outside expert, Dr. Mayer at National Jewish, but also Dr. Orent, the treating physician. And he renders that opinion, and, you know, that's where we stand. I really have nothing further to say on it, since I think this is a question of whether the evidence was sufficient to provide what we call substantial evidence. I still struggle with what that is, but thank you. Unless you have further questions, of course.
Mr. O'Toole, I have a question, the same question that Judge Bernard asked of Mr. Dworkin. Is there anything in the trio of opinions that are on point that we're discussing today that require a ranking of causes?
Unfortunately, having argued those cases, much to my chagrin and because I wasn't happy with the result, quite honestly. But no, there wasn't. What it really turned around was the ALJ may render an opinion that overcomes these. It doesn't say you have to do it. This is actually what I read when I read his opening brief. I look at, I guess it's their brief at page 29, as saying you have to rank them, and once you rank them, that ranking is dispositive of whether the statute applies. And our position is the statute is the statute. If it applies, it's because the evidence supports it, and the ALJ makes a determination that the evidence supported it. I recently lost a case on exactly these grounds. You're not going to see it up here because the ALJ made a reasoned opinion. So no, I don't think there's anything about ranking, creating a presumption of sufficiency. Because, in fact, we got the real issue. Risk doesn't equal cause. And, of course, I'm arguing this and have to say that my limitation with understanding words is evidenced by my lack of understanding fully of the sense of substantial evidence. But it's here. It was here. It's in the record. That's all I have. Any more questions? Thank you.
Counsel. Mr. Dworkin, you have 3 minutes, 34 seconds.
Thank you. Again, I'd point out in response that I read the town of Castle Rock to indicate that the ranking is required when it talks about the firefighters' particular risk factors render it more probable that it's setting forth the guidelines for the lower courts to do a ranking. There was comments concerning substantial evidence. It's our position regarding both substantial evidence and with respect to credibility determinations, excuse me, that neither of those are applicable when and if a judge uses the wrong legal standard, which is what we're alleging here. I'd also finish by saying in this particular case, if the ranking system was used, clearly the judge essentially did a ranking. He started to do a ranking system. He said, clearly the HPV is related. I'm not so sure about the carcinogens. And so with that ranking system in place, that leads to the only conclusion, which is that this is a non-work-related condition under the rebuttable presumption of the statute. And
Wouldn't somebody possibly draw the reverse conclusion from what you just said based upon the ALJ's reliance on the claimant's expert's testimony?
I'm not following the question.
Isn't it reasonable to infer that the ALJ thought that, excuse me, the testimony of the claimant's experts was more persuasive as to the cause, even though HPV was a factor?
That can be interpreted that way, but that's not what the judge said. The judge said clearly the HPV is a factor here. I'm not so sure about the exposures at work. And then the ALJ went on to say, as a result, I'm going to go with maybe there was this synergistic effect thing that happened, and I'm going to say that the employer did not overcome the presumption. But if he just completed the ranking and looked at it in his own words, the ranking was the HPV was a definite factor. The carcinogenic exposure, which hadn't occurred for 2 years, may or may not have been.
What happens under a circumstance where, when you rank them, you have the non-work-related factor ranking first, the work-related factor is subordinate to that, but really the greatest risk factor is the synergistic relationship between the two of them. Then does that, I mean, which side of the balance does that go on? And looking at the math here, the synergistic relationship between the two, at least based on the expert proffered by the claimant, was exactly to that effect.
And if there was science to support what that doctor argued, then I would agree that if you have the proof of a synergistic effect necessary for this, but that expert conceded that there was no such science with respect to HPV and firefighters. And
it was with respect to HPV and smoking, which was used as a proxy for work-related exposure for firefighters.
Correct, and
right?
this particular firefighter was a non-smoker. And so then the question became, was he ever exposed to smoke or things that are found in smoke, cigarette smoke, that could have applied? And the expert indicated, I can't be certain. I can't be certain as to when, and I can't be certain as to the amount. And so, to answer your question, yes, I suppose if there were enough facts, and I'm out of time if I may.
Please.
If there were enough facts to support a synergistic effect analysis, both in science and in fact, then yes, I think that could be the greatest risk factor, or the combination of risk factors.
And that goes on the side of the equation of work-related, right?
That would go on the side of, without the combination of effects, then it would, I would assume, go on the side of work-related, because that was the final straw, basically. But I didn't see that here, so.
Okay.
Thank you.
Thank you.
Thank you both very much for your arguments today. We appreciate them. The case will stand submitted and an opinion will issue in due course. This is the end of our oral arguments this morning. The bailiff may therefore announce the recess.